Добрий день. Today we are going to conduct the interview with Mr. Vitaly Koshlyak, the candidate to the position of the inspector and deputy head of the Service of the Inspectors. The interview will be conducted by the Selection Commission, which is today present in its whole composition. I'm Reda Moliene, the chair of the commission, and here are the members of the commission: Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelinchik. Do you have any requests regarding the composition of the commission? Thank you. The interview is expected to last for about 60 minutes. Commission members will ask you questions regarding your professional competence and skills, understanding of ethics, and adherence to the standards of ethics and integrity. Due to the limited time of the interview, you are kindly asked to be as concise and short as possible and not to speed because we have the interpretation. At the end of the interview, you will have several minutes, up to 5 minutes, for your final comments. The interview is broadcasted. Please be informed that parts of the interview can be held without broadcasting if the information which falls under restrictions for public disclosure under the martial law is under consideration. So the broadcast can be interrupted in any moment when you have this kind of information. So, can we start the interview? Thank you. So please take up to 10 minutes to tell us about your main aspects of your experience, which lets you come to this competition, and also your motivation, why you are going for these positions. So you have up to 10 minutes. Thank you.
Thank you. I'm a little bit nervous because this is not something mundane for me in my life. It doesn't happen often. I have been impressed by previous speeches of my colleagues, but it happened that I have to be the first today. Dear distinguished commissioners, I want to tell you about my motivation to take part in the competition, about my understanding, my vision of how the SDI should work, and I will talk to you about a story with balloons. My career started in 2005. I started as a regular assistant or prosecutor in a district in Kiev region. Back then the prosecutors and courts shared a lot of responsibilities to protect the main rights and freedoms of our population. The prosecutor's office was the only body that could protect the rights of citizens free of charge. But as the democratic institutions developed in Ukraine, the main burden to protect the rights of citizens was put onto the judiciary system. The opinion poll back in 2020, conducted with the support of the UNDP, showed positive trends, indicating that Ukrainians are prepared to defend their rights and are more tolerant towards each other. And the key values for the human rights, according to Ukrainians, included the freedom, 84%, justice, 73%, and security, 64%. Top 5 most important values also included the right to fair trial, 54%. When I visited European countries, I saw how the democratic institutions operate there. I saw how people value democratic values and how they respect them. And I see now how my family, my children are developing thanks to those values, and I have experience of working together with courts, and based on this experience, I want to contribute to the reform of the judiciary in Ukraine, because the future of my children and my country also depends on me. This is my motivation to take part in the competition. As we see, much is being said about the trust to the judiciary, which is one of the branches of government in Ukraine. According to the opinion poll in Ukraine carried out by USAID in 2021, only 10% of Ukrainians trusted the judiciary and 59% didn't. However, the main channels for getting information about the judiciary, about the reform of the judiciary, the main channel was the media. Another interesting fact, 86% of respondents were not involved into any judiciary proceedings over the past 24 months. What does it mean? It means that the society perceives the administration of justice through the prism of media and other sources of information. Certainly, both on public service and in the judiciary, there are, of course, examples, cases when the employees violate the laws and other pieces of legislation or internal rules of conduct. Let's call them the professional ethics codes. Reforms have been going on in the country for many years in particular in the integrity area, especially in the public service, and they are carried out in the judiciary as well. Since 2017, disciplinary chambers of the HCJ have brought to a disciplinary responsibility over 500 judges. And when the new composition of the HCJ started working since 2023, and when they started reviewing the disciplinary cases against the judges, and as a result of that, there have been 90 judges that have been brought to responsibility by this new composition of the HCJ. And I believe that the establishment of a new service that will have competent and professional lawyers will contribute to effective consideration of disciplinary cases. I think this review must be in line with the principles of legality, unbiasedness, fairness, competitiveness, equality of participants, and transparency. The new composition of the HCJ has taken a lot of steps toward this end. The staff of the HCJ consolidated the case law of disciplinary cases and published the results on the website. It ensured the public access to the international acts related to the main principles of activities and rules of conduct of judges. To the consultative opinions of international judges and other institutions. I believe that to ensure the respect to these principles, we need to introduce an open, transparent informational system about the progress of consideration of disciplinary cases that would contain information about the parties involved, about the dates and the progress of consideration of cases or appeals, so that a claimant and a judge in regard to whom a disciplinary complaint has been filed could have an objective opportunity to understand the progress of consideration of his or her case. And that covers the external observers as well, because the general public is interested in as well in the objectivity and openness of this kind of procedure. I believe that the rules of procedure in the HCJ and the regulations of the SDI need to clearly describe the authorities and role of the disciplinary inspectors during consideration of the cases, as well as the procedure of interaction of disciplinary inspectors with other structure, other parts of the HCJ. I believe that the SDI should not be a punitive body. It should be one of the tools that brings about trust to the judiciary, and also a body where the judges and the general public can expect the disciplinary cases to be completed transparently and with due respect to the necessary principles. And that will help to build trust of the general public to the judiciary, will raise trust to the judiciary system, and will satisfy the demand of the general public for the fair judiciary. And now the story about the balloons. I can compare my participation in the competition with a study where participants were given balloons, and the organizers asked them to blow the air so that they could explode, and they thought that only a few participants could do that. And I think that the same can refer to the people, because there are only a few can really go to the end and gain success. And me, at the end of this competition, I also say to myself, I am prepared, I am ready to go until the end. Thank you.
So now I will give the floor to the Commission member, Mr. John Ehrlich, to proceed with questions. Thank you.
Thank you very much for being here. We know that this process took a lot of work on all the candidates' parts, including yours, to fill in all the forms and have the background check and answer all of our questions. So thank you for participating and for your perseverance. I'd like to talk just a moment about your current job position. If you could just explain to us, if you would, what it is, what your position is, and what you do in that position.
That our interview is 90 minutes, not 60 minutes. So just for you to know, and for dear Commission members, I got into confusion. Thank you.
Thank you. I work in the Office of the General Prosecutor now as a prosecutor of the Division for the Procedural Management in the criminal cases that are investigated by the Bureau of the Economic Security of Ukraine. Since I've been working in this position since July 2024. Before that, before I was appointed to this position, since 2020, I had been working as a head of an office in the PGO. Then in 2021, I was appointed to the position of the deputy head of a directorate for the organization of procedural management in criminal cases related to the competence of the SBI, State Bureau of Investigations. And since 2022, since July, my structural unit was reorganized. Basically, its name was changed, and I had an administrative position, and there was another prosecutor appointed to my position. It is a regular situation when a head of a department is replaced. He or she normally wants to work with the prosecutors with whom he had worked before and whom he can trust, or she. And the procedure for such appointment is carried out with a recommendation of a head of the directorate who recommends to the leadership to appoint certain people to administrative positions in the appropriate department. I wasn't offered this position that I had before in this new division. Basically, the new unit wasn't new; it was renamed, but this is a gap in the legislation, in the law on the prosecutor's office, because this law definitely clearly says in Articles 41 and 51 on the law of prosecutor's office, it determines clearly the grounds for the termination of the duties of prosecutors and the grounds for suspension of a prosecutor from the position. But I wasn't suspended on any grounds. I continued carrying out my duties as a prosecutor. I had the administrative position as well. The scope of work only changed because I worked as a kind of prosecutor of a unit. That.
Thank you. What is the current scope of your work? Or what is the type of work that you are doing right now?
Now I carry out the procedural management in criminal proceedings that are investigated by the Bureau for Economic Security of Ukraine since July 2024.
An administrative position, or is this a first-line position?
Це виконавча посада.
It's a first line position. Front line, it's not administrative.
Apply for the administrative position when they disbanded your old structural unit?
There isn't such a procedure, because the appointment for administrative position in any prosecutorial body, except for the positions of deputies and the heads of prosecutorial bodies, is done upon the recommendation of the head of the structural unit. So even if I had applied, the head of the structural body could not really sign up to that and support my application. Back then, there were no internal investigations into me, into my job. There were no disciplinary proceedings against myself. No grounds, but still it just happened that when the leaders change, they see certain people on other positions in his division or department that he's appointed to. That's how it came about in my situation.
Why are you interested in this position, in the deputy head position of the SDI?
Well, you know, throughout my career, I've always been interested in developing, in growing. I am always studying the other areas of justice. I've applied in 2021. I applied to the position of the head of the state agency for land resources, but the competition never took place and they didn't choose the winner. I'm interested in developing myself, and I think I have experience, and I think I can work in this area as well.
What is your understanding of the role of the deputy head?
Ну,
Well, he helps the head of the SDI to organize work, because the head, I mean, if there is a position of a deputy head, it means that the head can delegate certain authorities to the deputy to ensure to organize the operation of the SDI. So I think it's more about organization related to the actual operation of the body.
You have applied for both the deputy head and for disciplinary inspector. Is there a reason you didn't apply for the head of the service?
Дякую за запитання.
Thanks for this question. I don't have a certificate and I don't know English. And I never checked the level of my command of English, but I think it's basic. Although it was interesting for me to learn it, and it's still interesting to learn English.
Foreign languages?
Ні.
No.
What is your understanding of what the service is going to do? The role of the service?
Роль служби
The role of the service is to review the complaints, disciplinary claims, to check whether judges' actions show any signs of disciplinary misconduct. It's about collecting evidence. It's about what is prescribed in the law. It's, I mean, to be a rapporteur during the review of a disciplinary case. It's been proactive in terms of collecting evidence about the disciplinary misconduct in the actions of a judge.
Once that evidence has been collected, you use the word rapporteur. How do you see the role of the rapporteur with respect to, for example, HCJ?
I think that the role of a rapporteur needs to be kind of active one. So he presents the materials, the files for the review at a session. He or she must submit the evidence collected as part of the review of the disciplinary case that corroborate whether the disciplinary misconduct has been committed or not committed by a judge. He also needs to offer to study certain evidence, maybe to interview some witnesses if necessary, maybe ask questions to the participants, to the parties of a disciplinary case. I think these authorities will be maybe more aligned based on the practical work and consideration of cases after the service starts to operate fully, because probably it's impossible to understand the whole gamut of the authorities that the disciplinary inspectors need to have before the service has started operating, because the laws change, authorities may be augmented, added, and so on.
What the authority is right now for the disciplinary inspectors?
According to the law on the HCJ, a disciplinary inspector must collect evidence in a disciplinary case, prepare opinions as to whether the disciplinary misconduct has been committed or not, submit documents for the review to the disciplinary chambers, take part in the sessions of the ACJ during the review of the decision of disciplinary body. So it's kind of a really active participation. That's what a disciplinary inspector does.
In your opening statement, you said that you did not see the role of the service as you said, it is not punitive. What did you mean by that?
Я мав на увазі,
I meant that the disciplinary inspectors and the SDI needs to study and try to collect as much evidence as possible that would enable a fair conclusion, fair opinion, to be able to tell whether the judge committed misconduct or not, and prepare an opinion based on this evidence on the basis of the principles of fairness. Because each case is unique and needs to be treated not only through the prism of legality, but also through the prism of fairness.
In your background and your experience that makes you particularly qualified for this position of deputy head?
I think I have sufficient experience in the field of law. I had worked representing the interests of the citizens and state in court. I worked in the area of procedural management and support of public prosecution in court. I have experience, I have managerial experience or administrative positions. And as I understand, as I see how other colleagues treat me, and I think that I am trusted, I'm respected in different teams, people trust me on different administrative positions, I think I am competent enough to organize people to achieve certain result. I think I have the competences needed.
You mentioned working with teams. Have you worked as a manager before over other people?
так,
Indeed, I did. It was the deputy head of a division, and a deputy head of a directorate in such structural units as where we had from 10 up to 30 employees.
To you?
Well, we distributed those authorities between the head of the structural unit and myself as a deputy head. For example, if there were up to 30 people in an office, in a directorate, then there would be like 15, 14 people under the different leaders. But if the leader, the head, was away on leave or medical leave, sick leave, then it was me who was acting as a head.
Management style.
спокійний,
I'm calm. I like to take my time to think over things. I think I treat others with due ethics standards. I can listen to the opinion of others. I can look at my actions from a critical perspective, and if my opinion is sort of wrong or doesn't is not in line with the law, I can listen to others if they say so, and when there is any discussion, I can really listen to my colleague or my opponent, and if he is right or she, I'm totally fine with it. I can accept it. And I try to develop my skills, and well, in most cases I can conduct a discussion on the level with my opponent, and I understand that if I'm right, I can make my case with due regard to the normative standards.
You are not just applying for a new job for you, but it's a new position that we are creating. The deputy head, the whole service is being newly created. What challenges do you see in fulfilling a job when it is a newly created position?
First of all, that's a new authority, new institution under the High Council of Justice, and the whole new stage of establishing of such authority will be closely monitored by the society, by public, how it works, the challenges. So I think that we need to understand, and I think that there will be some workload, definitely, because that's an institution which is being created from the scratch. It should be ensured with material things, so some equipment, with some things to work in proper conditions. Each idea has its own challenges, and that's both in terms of people, of human resources, of the team, in order to unite a group of people who work in order to achieve some kind of results. These are important areas of work for such authority and a new authority in the general judiciary system.
Thank you, Ms. Koshlak. I'm going to allow my colleagues to ask you some questions, but I appreciate your responses to my questions this afternoon.
Дякую.
Thank you.
Please.
Якщо можна.
Yes, if I may. So, greetings. I welcome you here. Thank you for coming. Thank you for participation in this competition. I have a clarifying question to you. Do I understand correctly that starting 2022, you haven't taken position of the second unit for organization of procedural guidance, deputy head of the second office for organization of procedural guidance of the SBI bodies in the Prosecutor General's office? No, I took this position as I was not dismissed from this position, and the structural unit, specifically the department which you mentioned, has changed its name, but my position is the same. So your position was titled the same. Yes. So you fulfilled the functions as the head of the second unit. So I indicated that the deputy head of the of this directorate. That's for the whole period of my work in the office. But when I submitted my documents for this competition, I was in the position of the deputy head of the second office. Only deputy head. Yeah, deputy head of the second office. There I mentioned it as using comma as my working experience, as a managerial experience. So I submitted my certificate from my place of work with indicated periods where I worked in the Prosecutor General's office. So I was at that position, but those functional duties which I should have had since 2022, I didn't have them because actually de facto I implemented the authorities of a prosecutor. So those works which I was assigned as a general prosecutor of a unit, but you didn't mention it when you submitted the documents. Now I was at that position, at that role. So in my CV it says those positions which the candidate has. I didn't pay attention to this because the fact that I was at that position at the moment of submission of documents and up to July 2024, I had been at that position. I had not been dismissed from that position. So here, that's, you know, such a collision when names of structural units could be changed, but positions, you know, I fulfilled the work, and I also received salaries, and for that period as a head, as a deputy head of this directorate, my working period also was accounted there. Also, okay, thank you. I have also a question. Greetings. Congratulations for you to come here and that you're on the last stage, namely the stage of interviews here. So my question is the following. Let's imagine that today is your first working day in the position of the deputy head of the Service of Disciplinary Inspectors. Your first working day. What will be your first steps? My first steps, so to meet the team, to meet leadership and the Secretariat of the High Council of Justice, because the Service of Disciplinary Inspectors is in the structure of the Secretariat and within the structure of the Secretariat. And also to understand how to arrange, how to organize work for the next day if there is a place already available, to have a meeting with the team for communication, to listen to their issues or existing problems in terms of organizing our work, more organizational issues which are related specifically to the beginning of functioning of the service. It could be also related to issues of transfer of disciplinary cases for consideration of the service. Also to ensure distribution of disciplinary cases, but they actually should be distributed in automatic way. So issues of more organizational nature for the first day in order to ensure functioning of the Service of Disciplinary Inspectors. Tell me please, you mentioned that it's extremely important to unite the team. Tell me please, what methods could you use in order to achieve this goal, to your opinion? That's to have meetings, to have communication in order to understand their experience, their competences, and authorities and powers. So what this person did in their past, to understand their best qualities, what this person is capable to understand their previous experience, what challenges they had in their work, and also to engage those employees into joint decision-making process, to listen to their opinion on this or that matter, for them to see that they're useful for the team, for them to be motivated to work for the sake of achievement of team results. Thank you. Tell me please the next question. So you mentioned that you also had some administrative positions at the previous place of work. Tell me, please, did you have any conflict situations in the team? And if there were any, how did you solve them? Of course, in any team, there are some conflicts between employees. I had conflicts which were not related specifically with myself. This, so to say, this was a conflict between a head of the structural unit in the directorate and the deputy head of this unit. They had some disagreements on how to arrange work in their unit, how to achieve working discipline at the unit. When I found out about those disagreements, I listened to their positions, to their standings on that matter. I also communicated with them in person, one-to-one. Then I arranged a meeting together with both of them, and as a result of those meetings, we managed to achieve some agreement how to further work, how to have some kind of joint solution which satisfied both of them, both of those managers. Tell me, please, are there any situations when you can't solve a conflict? No, I didn't have such situations. Thank you. If I may. Hello. Hello. Vitaly Ivanovich, please tell us. My question is the next one. Take into consideration that you took some administrative positions, who evaluated your work at those administrative positions? Speaking about the regional prosecutor's office, I was evaluated by the deputy prosecutor of the region, and at the prosecutor general's office, I was evaluated by the head of the department. Tell me, please, do you have any experience in evaluation of your subordinates? If there is such experience, how do you do it? Do you have some standard forms, standard methods, or do you have your own unique informal requirements to evaluate your subordinates? You know, when evaluations were applied in the office of the Prosecutor General, at that time I was already holding position of the deputy head. No. So when I was the head of the unit, at that time, there was a temporal procedure for evaluation in the Office of the Prosecutor General. System-wise, the system was developed by the Office of the Prosecutor General. Our managers, so leadership, developed some kind of a table in terms of fulfilling some duties and powers by an employee during a calendar year. And based on the workload and results, those employees received some scores. So there is a specific table, specific form which you used. And you didn't have any own unique requirements. Okay, thank you, clear. And my next question, the last question, which actually we ask very often to the judge candidates who have some experience as prosecutors in their past. So my question is, will your former past prosecutorial experience not become an obstacle to work without any biases, without fairness, and so on? Do you have any fears that it could become an obstacle? No, I think that my prosecutorial experience of my past will not become an obstacle, because I try to maintain the following principle. So you should treat other people the same way as you would like them to treat you. That's why... No, sorry to interrupt you, but it's not about, my question is not about your relations with the team, no, but I mean about the timing when you consider disciplinary cases. No, I think it will not become an obstacle, because there should be a balance, and between justice and fairness of decision made. When you prepare this the draft of this decision, you need to consider all the cases, all the facts, all the evidences which are being collected, and the decision shall be made exclusively on the basis of the principle of justice. if a judge has any signs of a disciplinary offense in their actions. And of course, first of all, you should follow the principle of justice and legitimacy. So there always should be a balance maintained.
Mr. Koszliak, I have two questions in this part. The first will be a follow-up to your statement about the public trust in judiciary. We all understand how important it is. And you mentioned that the low public trust exists in some countries. Ukraine, unfortunately, is one of them. And you mentioned that the public perceives the situation through media because they don't have the direct experience usually with the judicial system. Is this the main source of public distrust, or there are also other factors? Is the media the only or main factor which causes the low public trust, or there are other causes as well?
Ні, є інші.
Now, there are also other causes. It could be personal experience of citizens during some court proceedings. Always, when a case is heard in the court, there is always a party which is satisfied and another party which is not satisfied with the decision. And the party which is unsatisfied, they have their own attitude regarding the court through the lens of distrust because they do not agree with such decision, and using all possible challenging tools of the decision with which he or she does not agree. He could or she could stay on the same opinion, the same standing. The same, it could be you know, when you communicate, when you talk to your friends or acquaintances, it could be word of the mouth. Information could be disseminated in such a way regarding negative attitude or practice. When they, you know, they have this experience with court proceedings. It could be also internet. Now, right now, Telegram channels are so widespread where all information of any nature is posted, including court decisions and activities of the judiciary.
If I understand well, you didn't mention anything from within the judicial system or prosecutorial system which would be in such a bad shape that it would have the capacity to contribute to the low public trust. You mentioned the media, you mentioned the personal experience, particularly of those who lost the case, sharing such information, but I didn't hear anything about the functioning of the judicial system, about the wrongdoings in the prosecutorial system, about and all sorts of things within the system, not on the part of the public and its perception, but in the functioning of the legal system. Is it in such a good shape that it does not contribute? Or if you think it does, please name one or two or three types of defects or flaws which contribute to low public trust within judiciary or prosecutorial system.
Це може бути
It could be political impact or influence, both external and internal. Also, a presence of corruptional cases in the judiciary, which very often are published and disclosed in mass media, and they cause such kind of social explosion. But I would like to specify my position specifically regarding prosecutorial authorities and the attitude regarding them. In our law on prosecution, it envisages that the prosecutor is banned to So is banned to speak about any opinion of any procedural decision. Only according to procedural legislation we can prove that we are right during our work. That's why I didn't mention in my internal attitude into the judiciary system from the side of prosecutorial authorities, because exclusively within the provisions of procedural law, we can prove that we are right, but the code of prosecutorial ethics and the law on prosecutorial authorities, they clearly ban our any possible negative standings and opinions regarding actions and decisions of both judges and prosecutors.
I understand well that the ethics regime or code prohibits prosecutors to speak about problems within the prosecutor's office?
Ні.
No? So?
No?
Все вірно.
Yes, you're right. Not about prosecutorial system, but it bans to express their attitude or their opinion regarding judges, or that they don't agree with any judicial decisions. So they can't express their attitude regarding judicial decisions if they are made not for the interest of prosecutorial services.
We are speaking about two different issues. I am not asking about any individual case or judge's decision. I am talking about functioning or not so well functioning systems. Is it possible within the prosecutor's office to talk publicly about systemic problems and systemic flaws in rule of law in Ukraine? I think you understand my point. I hope.
Межах
Well, within the framework of certain cases or proceedings that communicate through press offices or media to the general public about certain facts, corruption actions, only as part of that.
I have one question, which is like follow-up question about this public trust. As you say, media contributes majorly to this shaping public opinion, and it's true. Media makes a huge influence. Do you see any role of this service, and particular the leadership of this service, with regard to changing this situation and media's and public opinion about court system, about justice system in Ukraine? And if yes, what particular responsibilities or actions do you envisage as helping to change this? Thank you.
Дякую за запитання.
Thank you for this question. I think that certainly the leadership of the SDA are gonna definitely have that kind of responsibilities as well, and their role will also will encompass the contribution to the change of this opinion. We can do that through the prism of communication with media, so media outreach, talking about the positive results to the public, to the general public. It can be done through communication with other public authorities, with the NGOs, because NGOs are also widely involved in the development and reform of the judiciary, and we see that happening, and a good example of that is the Public Council of Integrity, PCI.
I'm going to move on to a different topic, but before I do so, I feel I want to just follow up on my colleague's question. I think your observations about public trust or lack of public trust are very important. And I think your description of the sources of that public mistrust is probably correct. People get information largely from the media. But is the problem the reporting, or is the problem the system? In other words, if reporting is inaccurate, then there's a problem with that. So if all judges are honest and the media is saying judges are corrupt, that's a problem. But is that the problem, or is the problem that there's a lot of corruption in the system and the media is simply reporting on that? From your perspective.
From my perspective, it's rather the attitude about the general public and the people who see negative cases in the activities of some individual judges. And this kind of pushes them to general negative attitude. I think you can't judge about work of the whole body, a whole agency or public authority based on the examples of some staff, some employees, several employees, several officials, because the efficiency, effectiveness of certain public authority needs to be assessed through the prism of its results, its achievements. And positive and contribution to positive results for the general society. Certainly there are cases of illegal actions both in the judiciary and in the public service. I talked about that already, but the public tend to look more for negative things than positive things, because people tend to remember something negative better than positives, and than positive results or positive developments, achievements. I think it's just the way it has been in our society. The people judge a certain structure, a certain body based on certain social explosions.
I would like to move next, if I might, to some of the issues regarding integrity and property issues and such. I want to understand, if I might, your decision to obtain a certificate of law. And I believe you stated that there were some concerns about recertification of prosecutors, and that may have motivated your decision. Could you explain that a little bit more to the Commission, if you would, please?
Можу пояснити.
Sure. It was 2019 when a new reform or new wave of reform of the prosecutorial body started. It involved international experts, and the prosecutor staff had never come across that kind of development before. They couldn't understand how their work was going to be evaluated. And that's why I decided to receive the license to practice law as a defense lawyer. Just in case that if I cannot continue working in the prosecution after this attestation, I could practice law, so that I don't have any gap between my termination of the prosecutorial work and the beginning of the work as defense lawyer, because I have a family. I have a wife, and back then I had 2 children, and and I was the main breadwinner for the family, because my wife also worked as a civil servant, and her salary was much lower. So that's why that was my decision to get the license.
Time, was there any conflict of interest between your getting certified as a defense lawyer while you're working as a prosecutor?
Ні, не було.
No, there wasn't. I explained my position in the written form, and I also quoted the position of the ACJ as an authorized body that can judge whether it is okay or not okay to be double-headed, and I quoted the decision of the ACJ of 2019 and 2021, I guess. So there is a position that prosecutorial work cannot be carried out concurrently with other job, but it's only the work itself, the work, but not the status. What I mean is, when I received the license to practice law, I never worked as a defense lawyer, so I didn't work concurrently.
A ruling or a decision of the HCJ has changed at any time?
Ні, ні.
No.
Studying for we're all lawyers, or we're lawyers here. Studying for the bar, studying for a certificate is very time consuming. How were you able to work full time at the prosecutor's office and yet study to get your certificate?
Well, the curriculum was based so that you could study when you had free time, during weekends, and when I was on leave. So I really spent my time studying according to the curriculum. And studying to achieve the necessary standards to be able to defend my right to practice law and get this license.
To get the license, were you required to complete an internship?
Так.
Indeed.
And where did you do the internship?
With a defense lawyer in Kyiv. I can't remember now. It was 2019. I can't remember the name. I didn't check the documents.
How long was the internship?
According to the law, up to a year. The internship can last up to a year, but you can do it faster.
Did you do it?
Я не виходив.
Well, I didn't go beyond the deadline specified. I was doing that when I had free time. And this internship, I mean, I did that when I had free time, when time free from my work duties.
You worked with this defense lawyer. You mentioned a defense lawyer
Так.
that you did your
У
internship with.
адвоката. Так.
How long did you work with him or her?
Can't remember exactly. I think about 10 months. That was described in the set forth in the curriculum, but it doesn't require the kind of ongoing work with the defense lawyer. So it's about preparing procedural documents as required by the curriculum. That was mostly the case there.
Meet with this lawyer at times?
Так, так.
Yeah.
You meet with the lawyer.
About every week when I was free from my work. But I didn't have anything kind of to do work-wise with him back then, because back then I was representing the interest of the state under civil and economic or administrative cases, and he dealt mostly with criminal justice. So my work never overlapped with his interests or with his practicing law as a defense lawyer or with his individual cases or clients.
Did you ever attend court while you were interning with this lawyer?
Ні.
No, I didn't.
The lawyer's name?
На жаль, зараз
Unfortunately, not at the moment. I can't remember it right now.
To another topic, you had quite a few trips out of Ukraine during the martial law period. Could you explain that, please?
у мене троє дітей.
I have 3 children. The youngest is 4.5 years old. And when the full-scale invasion by Russia started, my family received an invitation from our friends who used to live in Ukraine near Bila Tserkva until 2017, and they invited my family to go to Germany, to their place, to secure their lives and health from those explosions, because the children's mental health can suffer from that. And it was that kind of situation when everyone was panicking, everyone tried to go anywhere where it was safe, and this family invited mine. We have friendly relationship with them. So, but because they couldn't take certain belongings with them, so they took only what they could at that moment, only in their hand luggage. And later, because I was entitled to leave Ukraine, because I have 3 children, and I used this opportunity to visit them in Germany and bring them necessary clothes, necessary belongings, because my youngest son was 2 years old, and he needed some clothes for a 2-year-old. And I also wanted to see my family and support them, because we were more or less used to that kind of events, but they were there at a huge distance, and they were scared even more. That's why I visited them to support them and support myself too.
I just have one more question. Do I understand that one of the homes that you and your family own was privatized?
квартира була
An apartment, yeah, in Kiev.
будує.
The house is still under construction.
House is the garden house.
Так, так.
Okay.
Yes.
Habitable right now?
Ні, там
No. No, the conditions are not in place. The renovation continues. You can't live there all the time. Especially given these events that are going on for over 2 years now, and since my family is not in Ukraine, so I really can't continue building it.
I'm going to let some of our other colleagues ask some questions, and thank you for your responses. Rita?
дякую вам за запитання.
Thank you for your questions.
I'd like to come back a little to this situation of obtaining this license for practicing as a lawyer. So you told us that the reason why you decided to obtain this license was this new system of attestation of prosecutors, and you were not sure if you would still be in a system after this. So what makes you think that? Either you were hesitant about your competences and going through this attestation, or you had some kind of a mistrust in a system that this attestation would be not performed or conducted in a objective and transparent manner. So what was your reason behind this plan B?
Ну, у нас просто в колективі така була
You know, in our team, we had this mood, this atmosphere that no one understood how it's going to be implemented. And there were more fears because in the public dimension, there are also were so many talks about distrust to the prosecutorial authorities. And because of this lack of knowledge, how it's going to be, because of this general atmosphere in the team, so it was, tensions. No one understood how this procedure is going to be implemented because it was first time, and no one understood what will be next.
Just one more little clarification or follow-up. So don't you think that this new service and position, especially leadership position in the Service of Disciplinary Inspectors, wouldn't be also very, well, sometimes with pressure, sometimes with this understanding that you don't know how would everything proceed, this feeling of uncertainty. So this kind of things that you discovered back then when facing this possible attestation. So what would be your then action if you get to the same position? What would be the action or plan B maybe?
ні.
From that time, many years have passed, 5-6 years. I have passed both the attestation and I participated in other competitions. And now everything is more transparent. And that's why I don't have already this fear. And I'm more responsible for my own actions, decisions made, whether to participate in this or that competition. And I'm more responsible for my understanding and vision of my role and at a certain position. I think that it will not influence and I will not have such fear because, with experience gained, with the years passing, you gain some kind of new experience and you can already perceive it in a different manner. And when you overcome this fear, or when you pass some challenges, you become a more resilient.
Yeah.
If I may, I have a clarifying question. John asked you a question regarding your border crossings to visit your family. So you have 3 children. Are they abroad now? Yes. Tell me, please, have they received any status? Yes. They received temporal protection status. So does that mean that your children are enrolled at school and nursery in Germany, nursery and school both? And does the state ensure them that yes, they receive some benefits? So it means that they could be there, your family, your wife and children. For me, not to ask you about the sources of income. So they receive the status, and correspondingly, they have some benefits from the state which issued to them this protection status. Okay, thank you. Clear.
Much. I will somehow connect the first part with the second part. In the meantime, I checked the code of prosecutorial ethics. And I have a few questions, but first of all, I need to clarify whether I can ask them. So I read in Article 29, relationships in teams of prosecutors' offices, that the relationships should be based on principles of mutual respect, that in relations between prosecutors, they should avoid manifestation of unfriendly attitude towards each other, and so on. And then there is this very important sentence: objective public criticism in the collectives of prosecutors' offices of shortcomings in the work of colleagues should be combined with respect, tolerance, restraint, and courtesy. Which means that this article offers a balance between criticism, which is possible, but it should be done in a very respectful, polite way. Is this the basis for restraint you mentioned in the previous discussion, or there is something else? Is this the one?
Це
No, that's a rule. These are rules related to internal behavior in a team. But I mentioned about responding public responses to illegal court decisions and a ban for a prosecutor to say negative opinions regarding publicly.
And I think it offers us a floor, because I don't want you to comment on or criticize any verdict of court, no. But you have a long career within the prosecutor's office. And I would like to ask you whether you were ever in a position that somebody asked you to do something what wasn't really okay, or whether you had any ethical dilemma in your workplace over the 20 years, and if you can tell us something about it.
Of course, there were such situations, because this work is related to some circumstances and existence of, when you work with some kind of perpetrators. And of course, there were requests. They reached out to me with requests to clarify some kind of information. But I'm more, focused on if there are any conflicts of values, certain values, then I'm more prone to take the side of values which are more valuable for the society, for my work, and for the team. Because in future, it impacts also on my status, on my authority, and also on my team's respect regarding me. And on communication with different people, including acquaintances. That's why I'm more on the side of the principle that the behavior should be exclusively within the limits of rules established by the internal documents.
So if you can be a little bit more specific, it would help me to understand one important fact, because maybe we will agree that the position of the disciplinary inspector may also happen to be under some kind of pressure. Whenever it can come from, somebody can have some interest and will try maybe to exercise this interest towards the inspector. So in order for us to understand that you will be able to sustain such pressure, we would like to see from your past that you are actually, you have that experience, that you are not, that within the 20 years, you somehow proved that you can walk the walk.
You know, I can give you the following circumstances as an example, which are connected to the events in Ukraine when I was reached out by some people with questions whether I could help them to solve the problem, how to avoid a mobilization. But as I have never had such experience, I don't have any such things at my work, and my functional duties were not related to functioning of conscription officers. That's why I told them that I can't help them. And that's all. You know, my position is the following, that if a person is drafted, if a person doesn't have any circumstances or conditions which could reserve him or her as, from mobilization and exclude them from mobilization, then they have this possibility, this to defend interest of the state, not only on the legal field, but also in other fields.
So let's imagine you will be the deputy head and one of the inspectors come to you and he goes like, well, I need to tell you that I had a very strange meeting with this respectful judge from this and this high court who said that I shouldn't probably pursue that and that case of his friend or relative or whoever, that it will be good for everyone. Of course, I don't have recording, but I don't know what to do. What would your response be as the deputy head to such situation?
I think that I will support him only within the limits of those rules which should be set up in the framework for this disciplinary case, and within those documents which he would collect as evidences for consideration of this disciplinary complaint. I think that this case should be also discussed with the head of the service in order to make a decision and also supports, helps this disciplinary inspector to protect him from possible additional influences or impacts on him regarding during the course of consideration of this disciplinary complaint against this judge who reached out to him, exclusively within the framework of the internal rules and rules of integrity and ethical behavior, and again, to underline, to repeat, to protect him from this impact and to help him.
Under the sentence within the limits of the actual case, what does it mean? What would be your action within that particular case? If you underlined, I will support him only within the framework of the case and the documents in the case. What would be your action, your support?
To listen to his opinion regarding availability of evidences and materials which could confirm lack of integrity in actions of this judge, and to make a fair decision if his opinion is based on those conclusions that he identified that behavior of that judge is non-integrant, then of course to help him and to report also to the head of the service, for him to be able to feel that we support him from our side, and for him to be capable to avoid this influence from the side of the judge. To look at all those case files, to come in, to speak with him and to make a joint decision regarding the final results. So specifically within the limits of legitimacy of collected evidences, to make a correct decision based on these things, on legitimacy and collected evidences, and not to stand on the side of the judge, but support a disciplinary inspector if indeed there are signs of illegitimate actions of the judge in that case. But each case is an individual case, but I think that, communication beyond the work of that judge who is the subject of this disciplinary complaint with this disciplinary inspector, I think that it's not acceptable.
Ever face such pressure yourself?
Specifically about such pressure, for me to be under pressure of a person who was a subject of a criminal offense, no, I didn't have such experience. For such cases, as you gave me as an example, no, I didn't have. So, what about your specific recommendations for a disciplinary inspector who would tell you that he had a meeting with a judge regarding a disciplinary complaint which is under consideration of this disciplinary inspector, and the judge had some proposals? I would advise him to deny such proposals, and I will promise him support if there are any further actions from the side of the judge with attempt to influence on the disciplinary inspector. And also, I will report to the head of the service for this situation to be known not only to me and disciplinary inspector, but also to the head of the service and maybe to law enforcement authorities if there is a proposal already offered from a judge to give some bribe. Tell me, please, to continue, this topic, tell me, please, if a disciplinary inspector has a conflict of interests. For example, if according to distribution of cases, this disciplinary inspector receives a case, a complaint regarding a judge whose assistant he was in the past. My actions, first of all, will be the following. So, first of all, a disciplinary inspector should report about this conflict of interests, and if it's identified by me from my side, I mean this fact, I need to respond to it, and actually I need to have a second distribution to be performed of this disciplinary complaint, for this disciplinary complaint to be assigned for another disciplinary inspector. Do you know, is there any procedure of self-recusals for disciplinary inspectors envisaged by legislation? No, legislation does not envisage it. No, but I think that in the regulation of the Service of Disciplinary Inspectors, such cases should be envisaged. Thank you.
And thank you for your participation and answers to our questions. Maybe you have some... Okay, we have 2 minutes, so okay, let's have one final question.
I just want to follow up with my colleague's question. So I think you were pretty clear that if there was a judge who was trying to influence the disciplinary inspector, that you would support that disciplinary inspector and you would talk to the head about it. And you would judge the case on the merits, not the disciplinary case on its merits, what the evidence was. Do you think that there's any procedure for investigating the judge who improperly contacted the disciplinary inspector and tried to influence him?
Certainly, it has been set forth in the criminal code. In legal influence on judge. And there is also an article in the legislation on prevention of corruption. Some out-of-office relationship and the procedure for investigation into that kind of fact.
Beside the criminal prosecution, the criminal aspect, do you think the service should take some action against that judge? In other words, initiate its own complaint?
Well, the law on the judiciary and the status of judges and the law on the HCJ set forth only 3 cases when a complaint, a disciplinary complaint can be initiated, and a disciplinary inspector has no right to initiate a case, and I think it was prescribed by the law on purpose to avoid any external influence on judges. Because that may amount to the influence on independence on judges, if a disciplinary inspector could make a decision to initiate a disciplinary case.
Thanks, Rita.
Thank you. So if you have some final comments or remarks, the floor is yours.
Thank you, distinguished commissioners. I want to thank you for this experience with the Commission. I wish you inspiration when you interview other participants of the competition. I wish you all the best. Thank you.
Thank you for your participation once again, and I would like to inform that the decision on the results of this competition will be made after 2 weeks, after the whole round of interviews with all candidates to this service. So thank you once again.
Thank you
Good
very much.
luck.
Thank you. Dziękuję.
Good afternoon, Ms. Anastasia. Today we are going to have an interview with one of the candidates to the position of the deputy head of the service and disciplinary inspector. This is Ms. Anastasia Matveychuk. So please be informed that the interview will be conducted by the selection commission, and today we are all present, all members of the commission are present. I'm Reda Molene, the chair of the commission, and also we have Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelinchik. Maybe you have some requests for towards the composition of the commission?
Ні, дякую.
No, thank you. No requests, no comments. Good afternoon, everyone.
Interview will last approximately 90 minutes, and the commission members will ask you questions regarding your professional competence, experience, and skills, and also will ask some questions regarding professional ethics and integrity. And due to time limit, you are kindly asked to be as short and concise in your answers as possible, so we could discuss more questions. And at the end of the interview, you will have several minutes for your final comments. And also please be informed that the interview is broadcasted, and in some parts of the interview can be held without broadcasting if the information which falls under restrictions for its public disclosure under the martial law is concerned. So if you have this kind of information, please inform the commission. If you don't have any questions so far,
No.
so we
No
can
questions.
start the interview. And at the beginning, I would like to ask you to make a short introduction about yourself, about your experience, and also what reasons bring you here and to apply for these positions, especially having in mind that you have quite an extensive experience as a lawyer in private sector, in business and enterprises. So please, the floor is yours, up to 10 minutes.
Ще раз.
Good afternoon, everyone, once again. While answering your question, I can say that I once heard a joke that everyone knows how to play soccer in Ukraine except for those 11 guys who actually are playing. And this is really indicative because it shows the difference between what you can do and how you can criticize someone else. I am prepared to work. I have the knowledge, I have the experience, both in the public sector and private sector. As a result, I can look at any situation from two perspectives. As a bureaucrat who knows what it's all about, structure, oversight, deadlines, and at the same time I have a perspective on the applicant. And as a person who wants a particular way or particular procedure with particular speed. I have diverse experience in the area of internal audit, maybe not as long as I wanted it to be, but still I managed to learn how a system works, and I know for a fact that there are always reserves, always backup for efficiency. You just need to find those reserves and make sure that that a system can continue working regardless of individuals, because individuals can change and should probably change sometimes, especially in the public sphere. I have an experience of scientific, academic activities. I've been a publicist, and what I like about it is that I can share my opinion. I can express my opinion despite of the position of a public entity, because you can start a discussion, you can generate the understanding of rules that are only being established, that are not in place at the moment. And this is a fantastic experience that helps me not to be afraid of any gaps in legislation or some discrepancies or some nuances that we don't know that should probably be filled, but for me, no rules is no obstacle. That's basically it. I'm prepared for change, and I'm prepared for to work. There is a lot of work ahead, but I think it is absolutely possible to sort it out and really set it up.
Commission member Olena Kovby to start questions.
Good afternoon, Anastasia. I welcome you at this important stage of your life, at this new stage, new service. And if the Commission makes a positive conclusion, and it would mean that there is a really interesting yet complex work that would await you. If you don't mind, let's start with the questions. Sure. Question number 1. How would you describe the concept of disciplinary responsibility and its essence? Disciplinary responsibility is a softer form of any other types of responsibility. So any misconduct, whatever it is, a minor one or an offense, it always entails responsibility. And disciplinary responsibility is an adequate type of punishment that starts if there is a misconduct committed. In your view, what is the main objective of the SDI? And how do you see your role in the establishment of the SDI? The SDI is going to be a support unit that should contribute to the operation of the HCJ in terms of establishing the process for consideration of complaints that have been received and that will be received in the future. So all the disciplinary inspectors and the leadership of SDI will have the following objective. Every person has right to be heard. If you speak in a written form, then it takes the form of a complaint that needs to be considered. Even if it was filed many years ago, long time ago, anyone has the right to be heard. This is going to be the objective of disciplinary inspectors, to help everyone to be heard. How about your role for the establishment of this service, for the operation of the service? Well, if this is a role of a disciplinary inspector, it will be the same, to consider the complaints, to do the preliminary consideration, to make sure that every voice is heard. If I am a deputy head, then along with objective number 1, that would be contributing to the organization of the whole service. If there is a positive conclusion, and if you are appointed to the position of deputy head, what are going to be your first steps? First steps, well, to meet all the members of the HCJ, to establish communication, to decide on common principles, because this is a live process. We're all humans, and there should be some rules, some principles, and organization. All the principles are not always clear from the rules of procedure. You need to understand how the actual cooperation looks like, because you probably can't use simple words in the rules of procedure to understand the whole gamut of the work. Second point, to read the electronic documents, because I think this system has been in place for some time, and if the scope of work has been digitalized in some way, that means that you can apply certain filtration principles to accelerate the consideration of the available complaints, because I really believe that about 80% of complaints have been not considered for different reasons. Unfortunately, the statistics is like that. Many years ago, I remember I applied for the constitutional request And I realized that if you don't work in this area, in this really narrow area, as with constitutional requests, then even if you have a degree in law, it doesn't mean that you can file this request appropriately. And unfortunately, most of the complaints that are still pending will have the same future. I'm afraid, but it's not a tragedy, because if you know what kind of mistake you have made and you know how the process should look like, then you can remove the mistake, and then you can resubmit the claim without wasting the time of the people that don't need to consider complaints that have been unduly filed. So that's my next objective. Next step, to learn about the objectives, maybe some rules or of the work, because apparently some work is being done today, but with the people who are working today and with the resources that they have today. Certainly, I think that people continue filing requests or claims, complaints, and witnesses are being heard, and so on and forth. So you can find additional resources for that as well. So reading all these, rules, learning about the current procedures, that would be a nice step. Development of the regulation of the SDI, or finalizing it if it has only been drafted. Maybe discussing some alternative ways about how to organize the work, depending on the scope of the service on the first step, on the first stage, because as I understand, 100% of all claims won't be possibly considered yet, and that would affect the efficiency. But that's about it, I guess. The rest will come as we continue working. Thank you. You have applied for the position of the head of SDI as of today. Also, we are now interviewing you as a candidate for the deputy head position and the position of a DI. Still, out of those three positions, where would you feel more comfortable, on which of those three, and where would you be able to show your professional skills? Well, I didn't apply for the head in January. Because I didn't have the English knowledge certificate, and I didn't have really time to get it. But now I have resubmitted my application because I believe I have really met the requirements of the competition. And I certainly will give advantage to a managerial position. I think at the point or at this point in my life, with all the knowledge and experience that I've got, I think I can fulfill all my capacities and potential on the position of the head.
Next question. To your opinion, why actually, according to the law, one of the requirements for a person applying for positions in the Service of Disciplinary Inspectors is compliance with judicial ethical standards? American concept of the legal system guarantees to all citizens a fair trial. In this context, in Ukraine, this model was implemented, for example, in the HCJ work, because HCJ members actually ensure fair, of equal trial for others, and disciplinary inspectors actually are related to it, even if they do not make decisions on the merits. But anyway, this it's clear that the same requirements should be applied regarding disciplinary inspectors in order to be able to speak indeed about such fair trial. Thank you. According to your CV, right now you are holding the position of legal advisory of the legal department. So, for example, let's imagine this following situation. You take the position of the head, and once you've got a disciplinary complaint regarding a judge who considered the case about your enterprise in the past, and the decision was made not in your interest. So, what will be your actions? If this case was started when I was working there, then I will submit a self-recusal. Actually, we don't have quite a few such cases. That's why I'm sure I will not be lost in my memory. But if those cases were started after I was dismissed from that work, I don't see any correlation, any relation with me on these cases. Okay, thank you. Can you tell me if you have any doubts in terms of when you make a decision, what will be, a final for you, a final word for you, decision or opinion of the team or your own belief? As far as I understand, the concept of the HCJ law, the Service of the Disciplinary Inspectors, is actually a table of knights of round table. So it means that the head and the deputy head are there just first among their peers, and it means that among other equal. So it means that the head or deputy head do not have any other extra managerial functions. There is no envisaged system of agreeing of such documents, or the head or the deputy head will not impact in any way on the salary of families, because the model of calculating salaries is well known, and there are no incentives or motivational payments being paid. They will not impact on the career of employees, because actually this position doesn't envisage any career development. It's a contract for 5 years, and all conditions are known for everyone. They're equal for everyone. That's why I don't see any significant role which could be played by the head, for example, or deputy head, when they discuss it with such decisions with colleagues. And in terms of discussing such matters between inspectors, it's even more to say. All of them have their own opinions. They're independent. They're based on consideration of the case files, their own knowledge, perception, understanding, vision, and so on. Even not mentioning the fact that no single employee of this team, of this service, has no previous experience in service, because this union, this service, has not been established before. That's why no one has more or less experience in terms of disciplinary responsibilities. That's why opinion of colleagues could be heard, but it will not impact finally on my opinion. Tell me, please, if such characteristic is related to you, how would you comment it? Very ambitious is not ready to pay all her time to the work, especially if she doesn't see the results of her work. She is more effective on executive positions, on doing positions rather than managerial positions. Yeah, maybe on some stages of my life it's true. It relates to my characteristics, saying such things as she's not ready to pay all her time to the work. Yeah, maybe it will be true till the end of my life. But for now, I'm already ready to apply for the managerial position and to prove my efficiency, not just as a rank and file employee, but also as a managerial position. Even if you don't see any final results, but are you sure that you will achieve some results which could be expected from your side by judges, society, and public? So take into consideration this specific position, its duration, and the plan of work. So everything will be very specific, with very specific periods of time. We don't work from today till lunch. No, we have very specific rules of procedure, and I believe that all the results could be measurable. Of course, we can't meet all expectations. Even sun could cause allergy for some people. So but I believe that with due organization of our work, our results will be achieved, and we'll have what to share about them. Thank you. Tell me, please, you have experience of managing big teams. If yes, then please tell in details. I mean, the number of people. So, as it's expected in the Service of Disciplinary Inspectors for a team more than 50 people. So because 24 is disciplinary inspectors plus 2 managerial positions and plus equivalent number of additional staff. I don't have such experience of managing a team of 50 plus persons. I had for 2 years a position of head of the legal department, and I also fulfilled functions of the head of the unit when I was a civil servant, but I had up to 5 persons under my subordination, not more. But at the same time, I don't think that that's a problem, because as I mentioned before, I can see that the concept of a round table could be applied here. It means that I don't think that disciplinary inspectors require some kind of, harsh and strict hierarchy and some significant leverages of impact. The head influences very little. Even if he or she doesn't influence on distribution of cases, because special software is applied here. It means there is a function of general management is still there, and also moderation of emotionally acceptable environment in the team. Also, other functions of the head is to solve some organizational issues with support of secretariat. For example, if there are some issues with the salary, whether it's paid enough or not paid, or a laptop is broken or something like this. That's why I think that I have enough managerial experience to manage such a big team. Thank you. Tell me, please, can you name 5 key your features, managerial features? So I'm goal oriented. That's the first. That's the first my characteristic, because as it was mentioned in the description, when I don't see where I go, I don't see the results, it doesn't suit me. That's why I usually develop such bullet points, such goals for myself, my subordinates, and for people. It's always easier to go forward when they know where they go. Then the second is being structurist, because such words as multitask person, they equal to a chaotic person. It doesn't suit me. I always want to see structure of who is doing and what is doing. Someone likes to do some gardening, or others hate it and prefer to work with papers, and that's why you don't need to break that person where it's not needed. And third, my characteristic, I'm not, I'm not so fond of labor, and I'm not a workaholic, and I value my family life, and I work-life balance. I adore work-life balance. That's why I think that all people, those people who are calm, who are happy in their personal life, they will be the same efficient at their work. They will be happy to go to their work. They will have no scandals, no hysterical situations, no breakdowns. That's why this my third advantage. The fourth advantage, I fully believe that there should be adequate payment for the job done. That's why any ideas which are focused on increased efficiency and correspondingly increased salary, or more appropriate distribution of working time and rest time, and it's especially relevant for the private sector. For example, to do the same job but with less time or with higher money, and which and it will allow more time for this person for personal development or for their family time. You always should look for such things, for such opportunities. And number 5, I love people. That's all. Thank you. Let's imagine the situation that you take this position of the head or deputy head of the service, and once in mass media you have this news regarding non lack of objectivity in your in carrying out functions of the service, because there is a pressure on one of your subordinates, or on disciplinary inspectors who has a disciplinary complaint under their consideration. What will be your actions? You know, freedom of speech has its own drawbacks. So they publish it, okay, let them do it. Depending on specific circumstances of the case, there could be different actions from my side. For example, doing nothing, because it could be also just, you know, a post on the website without any feedback mechanism, or without name of an editor or an author. Even in my private practice, I face such posts. You can't fight them, because sometimes it happens. Sometimes you just have this information, but no focal point, no contact details, whom to call, whom to challenge at the court, and so on. You even can't call it, say, please listen to my opinion. If it happens, okay, they have their own business. Let people publish what they do. But if that's absolutely different information or message, if that's an official mass media, if there are specific names mentioned in that post, or leverages of impact, of influence, or any other things which from perspective of the, you know, smart person requires some actions, and yes, maybe a repeated automatic distribution of cases should be done, and this case should be assigned to another disciplinary inspector. Thank you. Do you have any questions regarding this specific topic? Hello? Anastasia Alexandrina, just now you told me so you just now told how many disciplinary complaints right now under consideration of members of the SCJ, and they of course are so waiting, so looking forward for establishing the Service of Disciplinary Inspectors, because the balance of personal and working time for members of SCJ is also an important issue. But I would like to ask you the following: how easy do you face heavy workload, and are you ready to have such heavy workload in your work? Yeah, I'm absolutely easy to have a lot of work, but at the same time, or a lot of workload, but at the same time, we need to understand that you know, workload can't be constantly on the extra high level. That's why adequate plan and adequate figures which will allow to distribute or divide this work into small stages, you know, it could be worked. And there is such a proverb that, you know, you shall do your work, your thing, step by step. And that's why, if such work is could be adequately divided into small parts, which will allow intensive works, but not for, you know, for full exhaustion. I don't believe that a person could work for 12 hours with the same intensivity of their job done. I even don't believe that 8 hours of the same intensivity is enough, because, you know, there could be a high rate of work, a high speed of work, but adequate one, taking into consideration that there could be some extra emergency situations, because one day there could be a rate alert, which, for example, as now lasts for 8 hours, another day electronic documents turnover system breaks, or any other things, but, you know, step by step, and we'll manage it. Okay, tell me please, what do you think about delegation of duties, and which duties or tasks do you usually delegate? I welcome delegation of duties in all forms. Any duties that you don't like could be delegated. So that's a frank, sincere reply. That's what I mentioned. Everyone should do what they like, what they are most prone to. And if you don't like some specific thing, 100% there will be another person who will like to do it and will do it very well. Thank you so much for your replies. As you're a person quite frank, and of course, me personally, I like it so much. And tell me, please, do you have any gaps in knowledge related to your work? And if yes, how would you like to compensate it, or do you plan to cover somehow those gaps? Of course, there will be some gaps, related to specifically to this job, because my autobiography says very clearly that I have never worked in court before. I have never had any relation de facto to disciplinary proceedings, maybe with exemption of some cases when I wanted to be involved. Yeah, there are some gaps, but they could be covered. Anyway, if I prepared myself for the practical assignment, I would be able to do the same with covering those gaps which I have in order to consider disciplinary complaints. You know, you had very good score for practical assignments. Was it difficult? It was a new thing, but it was also an interesting for me. And also, I was surprised that some issues were taken out from the task in comparison with the example. Because when I prepared myself, I looked at the example of the case that, for example, there is a specific system, could be this sanction, could be another sanction. So that's why I think that this question was taken out from the task, because it was too schematical. Okay, we will take into consideration for the next competition. Yeah, everything was very interesting. I just observed and noticed that one question is missing, so maybe it was too easy. Anastasia Alexandrovna, if I'm not mistaken, in your speech you mentioned that you need to develop relations with the HCJ members. According to which principles you are going to build such relations, and regarding which matters? The issues of cooperation, of interaction with HCJ members actually stays on two levels, on the level of a specific person and on the level of a specific unit. According to normative legislation, for now, there are no significant reasons for communication, for daily communication. You know, materials are submitted or delivered to a disciplinary inspector, then it's submitted to the HCJ's relevant unit, then it's reported there, and so on. Everything is clear. But then the work starts, and in order to start this work, we need to synchronize actions of some people. Some people should see it somewhere. Those people should dig into details of the work. Those people should actually take those cases, accept those cases, and also publish this information in the Voice of Ukraine. But you know, this can't be done within one day. It's just impossible. It means that some kind of transitional period will take place, and within this transitional period, it will be obligatory and unavoidably needed to meet each other, because it's a next 5-year period task. It will be a team. Yes, each person will do their own job, but at the same time, we are not robots, and I think that it's unacceptable for a situation that interaction happens only on paper, but without personal interaction. It's not effective. It's just, paper, signature, so on, and you can't find that mistake easily, especially if this mistake is hidden somewhere behind the polite phrases. That's why maybe on the first stage it will be feasible to have some meetings for for understanding some general principles and basis for work, especially that only HTJ, as that no HTJ member knows how disciplinary inspectors will, only HTJ members know how the disciplinary inspectors will work because they are now doing this job. That's why it's extremely important to exchange this opinion, to understand what works well, what doesn't work well, what we would like to see, we will, don't want to see at the job in order to achieve some efficient outcomes. That's why first meetings would be effective.
Maybe some distribution of the DIs into groups and their assignments to disciplinary chambers, because some of them may know better the criminal process, others economic processes and so on. And this sort of specialization will help us to avoid mistakes or avoid those gaps in qualification that we already discussed. Maybe some rotation would be needed in the future so that people don't get stuck in one area but could develop their competence, and then we could handle more complaints. Maybe this format would not be needed in the future when we have all the mechanisms set, but certain organizational things need to happen on the first stage. The SDI will sit in another room. Certainly if you sit in another room, in other premises, it doesn't contribute to your effective work because you need kind of some time to visit each other, to agree on the meeting. So sometimes you just need to talk to real people, to get things straight.
To come back to your motivation and how you described, how you understand the mission of this service. So you emphasize that the mission is to ensure that every person is being heard, and that every complaint is solved. So we know that the public trust in judiciary in Ukraine, as in some other countries, it's not a very exception, but still it is quite low. And one of the reasons of creating this service is, of course, making more effective disciplinary actions, but also to develop this public trust, to improve this public trust. So how do you see how this mission, as you understand and describe, would contribute to this improvement of public trust?
Недовіра до системи правосуддя.
The mistrust to the judiciary in Ukraine is something that we inherited. Over the past 300 years, the state has not been a friend to a citizen, and the court also contributed to such mistrust, but this is something that is going to into the past now. And one of the factors that contributes to it is the met expectations of anyone when anyone approaches any institution. And I have already seen how the attitudes of people change. One case gives more trust to a person who can share this trust to dozens of others, advising to find a good lawyer and so on. So every considered case will also contribute to better trust. People will believe that if they file a claim or complaint, you will get result eventually. Certainly some public outreach would be needed, because when you consider 100 cases of 200 cases, we can already see that these are the mistakes that you committed, dear applicants. This is the field that you need to fill out. This is the thing that you need to take into account, and everything would be fine afterwards. So the system that really answers to your request, that contributes to the trust and enhances the authority to the judiciary. And this is where the SDI can help, because it will give people hope that when they approach the SDI, they will be heard.
It's very important, and that every person matters, and the expectations of every person and opinion of every person matters, especially, as you say, when these people are talking to their relatives, to their friends, and this news are spreading. Anyway, I think that this public trust is more global or more complex issue and challenge. And do you think, and if you do think, how this service could contribute even more to this public trust in more complex way? How it contributes, not only like responding to complaints, but also building some kind of other culture or so, please.
Направду кажучи, я розглядаю.
Well, I consider the SDI as a support unit, kind of number 2 unit, someone that stands behind your back and helps. The SDI does not make any independent decisions, and I think it should not play a kind of advanced role as a kind of keystone to any dramatic changes without which the whole world would collapse. I want to underline the fact that the decisions are made by the HCJ. This is the authority prescribed by law that has the necessary powers, competence, and so on. But an effective work of the SDI would contribute to the trust to the HCJ, and that would be only like that, because most overwhelming majority, like 99% of my relatives or friends, they won't understand where I may work if I just tell them. I don't have many defense lawyers who have ever filed a complaint with the SDI, because this is normally not something that defense lawyers like to do. They don't want their names to be associated with the claim or complaint against the SDI, to the SDI with some name of a judge. So I don't think this work is going to be really public one. I used to work in an audit service of Ukraine, and I understand that when you work like that in that kind of institution, you are small details, small mechanism, but still you are important for the operation of whole system. But most people won't understand what you do. They would say something like, "Oh, it's a public service, so you are somewhere, well, there." So this is the way I look at that. People will just know that this is something that actually works. Their complaint has been filed, and now they have a chance that, I mean, if there was a situation in court that they believe is not acceptable, and they believe that they didn't see the justice where it was supposed to be, but they will know that there is another authority where you will be heard. I think that would be enough. And I think if we achieve that, that would be a wow.
To ask a question about your motivation. As you said in your introduction, that it's better to act than just to criticize, and this is your approach, which I appreciate a lot. And with regard to your career in the Supreme Court, so was this career and your position in the Supreme Court, which was called like about a year, this kind of motivation to go there after some private practice and to do something instead just of criticizing?
Моя мотивація на працевлаштування в Верховному суді.
My motivation was a little bit different when I joined the Supreme Court. It was the autumn of 2022. everywhere was a chaos, and my idea was not to go somewhere and change something, but to go and learn something. And my boss, the head of the unit for internal audit, she was a very well experienced lady with a huge knowledge, and I wanted to expand my knowledge, my competence in this area, because I used to work in the financial internal control body, but I had another perspective. I was a legal advisor who addresses the matter like whether there was a violation or not, how you interpret the law, what needs to be changed in law so that it doesn't have any loopholes and no one tries to avoid, paying something. So I had that kind of experience, but from another perspective, from another position, and I wanted to enhance my knowledge in this area, in the area of internal audit. Also, stability back then was important to me, and that position gave it.
Building or improving this competence was enough.
Так.
It was. Yeah, 1 year was enough. But later those opportunities disappeared. Unfortunately, my supervisor retired, and my opportunities to learn from her ended, and as a result my tenure there ended as well.
To ask, so you described these skills which in your opinion would help to have a lead on some team, and also you told that you have an experience of having a team of 5 people or so, and that it is sometimes or very often it's similar. The principles of this leadership are similar than leading the huge team. So this is also with challenges, I guess. So what the most important challenges you faced while leading the team and managing the team of people? So 3 main important challenges which would also be apparent here.
Перший виклик основний.
Well, challenge number 1, that would be to understand the other people. You understand what they want, what they are committed to, what are their priorities. Sometimes it's not written down, and sometimes information can be interpreted from different ways, in different ways. So when you manage teams, when you manage people, the first challenge is to understand what these people strive for. Second challenge, you understand what matches their intention, because sometimes our desires do not match our opportunities or resources that we have. And the challenge number 3 is to maintain a team, because everyone develops, everyone grows, everyone moves on in their lives, and sometimes it doesn't coincide with what the team wants. I saw that happening with my supervisor. I remember I sometimes was not disagreed with my supervisor because his actions didn't agree with mine. But if I were him, I would have done the same probably.
You deal with them. So how to understand people, how to respond to their expectations and demands. So what did you do?
З помилками.
Well, I made some mistakes, I had my share of mistakes, but I tried to address it with joint work, with cooperation. Through that communication, you learn what people need, what they want. But sometimes mistakes happen, and you always need to follow your way. To go. If you go with the team, that's one thing. But if you go in another direction, then probably you need to do something else.
Dobre den. Thank you for being here this afternoon, for answering all of our questions. Are you familiar with the legislation that created the SDI?
Так, звичайно.
Sure.
Legislation?
Ну,
Yes, I did, to be prepared for the competition. Legislation is really something fluid. It changes fast, and the ways to interpret change even faster. So, reading legislation at some stage is one thing, but implementing it is another thing, and willing to change it if you see something it doesn't work is another thing. So yes, at the moment, yes, I have read the laws, but this is an ongoing process, isn't it?
So you have used the term support unit several times to describe your understanding of the role of the SDI and HCJ. What do you mean by support unit?
According to the law on the ACJ, the SDI is an independent structural unit of the Secretariat. The independent structural unit means that this unit does not belong to other units, so it can't be a part of something else. As a result, the head of the SDI ex officio is a deputy head of the Secretariat, so he reports directly to the head of the Secretariat of the ACJ. And the Secretariat is a totality of the support units. So the SDI is a good name. I mean, we call it service, not department, not unit, not directorate, but we call it a service. Yet, at the same time, a legal service is only just a service, although it can be called a department. So an independent structural unit does not mean that is kind of independent from the authority where it works, where it operates. It's a kind of support unit that ensures the operation of the Secretariat of the HCJ. So it's a part of the Secretariat.
Head of the SDI reporting to the Secretariat of HCJ.
я не впевнена.
I don't understand your question correctly. I don't think so. What kind of influence the ACJ may have on the head? Do you mean that?
Вища рада правосуддя – це
The ACJ is a collective body, so the influence scope is not that big that it may look like at first glance. The HCJ will establish the principles of operation, will approve the regulation that will be the job description for the head of the SDI. But the mechanisms for the reciprocal influence on the review or review, well, it's not prescribed, but there will be cooperation, there will be interaction, because the SDI cannot be juxtaposed the SDI as HCJ as a sort of independent body that has its own life. It's not a body, it's not even a legal entity, it's just a support unit, and the objective of it is to help to deal with the scope of the complaints and to establish the necessary mechanism for review of complaints that will be filed in the future. But it won't be separated in any way, and it should not be committed to become an independent body that will challenge the decision of the HCJ. No, it's not. I see its role as a kind of support unit, support entity.
The role of the disciplinary inspector in presenting an opinion to the disciplinary chamber of the HCJ.
This is that part which is regulated also by the law on HCJ and in the rules of procedure S. Disciplinary inspector is a reporter, and he or she is a participant of the process with all rights. So he or she has rights plus duties. So he or she reports about the case, identifies a circle of witnesses that should be listened to, and also identifies key aspects. If it's needed, also could submit motions, so on. The only thing which can't be done by a disciplinary inspector is challenge a decision of the High Council of Justice, and correspondingly, he or she reports at full, but at the same time, of course, without having any discussions between plaintiff, defendant, and judge, who is the subject of the disciplinary complaint. But at the same time, a disciplinary inspector is a full-fledged participant of the process, because a meeting could be without a judge, without a defendant in some cases, but without a disciplinary inspector, such meetings can't take place.
Do you see the role of I'm trying to understand, when you say participant, the degree to which the disciplinary inspector participates. Is it as an advocate, or as a prosecutor, or as a defender of his opinion, or just strictly as a rapporteur?
Я вважаю, що
I think that a disciplinary inspector is not an advocate, nor a prosecutor, it's just a moderator, yes, so to say, of this process. So he or she collected documents preliminary. In this case, he or she has all, preliminary explanations, and explained and provided a draft of the conclusions which they submitted to the High Council of Justice. And so it means that the disciplinary inspector should tell general conditions, what happened in that case, what are relevant norms of legislation should be applied, and so on. But he or she does not enter into discussions with parties, and does not provide explanations to the parties. Their duty is to report to the disciplinary chamber rather than to a plaintiff.
Normative rules and regulations. What experience have you had with regulations and codes involving judicial ethics?
Як я казала,
As I mentioned, I have almost no experience regarding work with different disciplinary procedures. A part of several cases when I just wanted to draft a disciplinary complaint or file a disciplinary complaint, but I was not a subject of that case. So in this sphere, I could have some gaps in terms of my competences, which the question was asked by Olga, but I could cover them. I have legislation for it. I have generalized practice prepared by HCJ. So yeah, that's how there is a good Ukrainian proverb that not gods make some cooking utensils. So I'm sure that a specialist could handle it.
You ever read the Code of Judicial Conduct? The
так,
Ukrainian?
так, звичайно.
Okay.
Yes, of course.
Familiar with the Bangalore principles?
Так, безсумнівно.
Yes, for sure. Even I referred to them in my reply to practical assignment.
All right. Those are the questions I have for now. Thank you.
Дякую вам.
Thank you.
The one who will follow. Please, what is Oxford Kids Association? We found in the declaration that you had some connection. What is it and what it does?
Oxford Kids.
Oxford Kids, that's a small civic organization which has been established, I think, during lockdown time, somewhere back to 2020, 2021. This is my friends who decided to create such a club for development of children, for everyone to join and participate, and I became one of the founders. And I also am still a founder, and it's actually very convenient when if any changes for registration should be done. It's just a club or a group for having classes for development of children. At that time, my child was enrolled in nursery, and it was needed for me.
Now I move to other types of questions. I will follow up on the last portion. In some countries, one of the key factors contributing to low public trust or public distrust towards judiciary is when those who committed something wrong are acquitted and those who did nothing wrong are being prosecuted. Different countries experience this type of problems. Have you observed any flaws in the Ukrainian disciplinary system over the, for example, past decade? We have now 2024, so let's go between 2010 and now.
I have not followed the practice of disciplinary proceedings. It was out of my circle of interest, but I could definitely say that in terms of general trust to the justice, the judicial system, when I started working back to the millennium years, at that time the court fee was so low, it was just extremely low, and the high extremal level of bribes in courts. Bribe was considered as additional court fee. There could be nothing done without those bribes. Those bribes were just considered everywhere, as it just should be, because the universe was built like this. But now it doesn't work like this. 20 years ago, when I was just a student, everyone was looking for a lawyer with some connections, because other lawyers would not suit, because lawyers with connections can't help you. It doesn't matter how a person is smart if he or she can't help you. Now situation is absolutely different. And I'm so happy to observe it, not just on the domestic level. I mean some civil proceedings where we have civilians involved, but also on the level of the business, so commercial suits. So, for example, people are not afraid of submitting or filing a complaint against the tax authorities of Ukraine. It's okay. Yeah, I will do it if it's wrong. So it's already, it's a mentality of a person. So when you go to a court, you have a court fee, you have lawyers, honorarium, for example, for the court fee. It could be quite long time to return it, but anyway you will manage to do it, you will succeed. But even despite of the fact that there is lack of this some kind of disciplinary responsibility, I definitely know that for the last 20 years the trust to the judiciary has increased significantly, drastically. Situation is absolutely different what is now and what was back to 2005. That's why with such dynamic I could expect that maybe not my children, but maybe my grandchildren will never know about bribes in courts. They will know about it only from the history books.
Which one of the principles is the one which you are most inspired by, or you value most, or you think it's the most important among all of them?
I love all of them. Maybe I will just generalize into one principle: be a human being, and that's all. But in all other ways, they work fine for me.
Is a principle within the Bangalore principles?
Якщо їх всі
If we unite them all in one, they sound like this.
Accept this answer. And now, when we have independence, impartiality, propriety, and so on, among these, could you name one which you consider, maybe for Ukrainian context, maybe for the Service of Disciplinary functioning, the one which deserves to be, very thoroughly considered when the disciplinary service will be functioning?
professionalism. Yeah, indeed. So professionalism for me will value the most, because people who know laws, who respect laws, and who want that laws applied regarding them specifically in such a manner will also apply them in a right, correct manner. That's why this is the first place. Independence, impartiality, that's all is good. These are additional components, but professionalism shall be the first one.
Let's discuss one scenario. Maybe it's totally abstract, maybe it will never happen in Ukraine. I can imagine countries when it happens, even now. The disciplinary inspector comes to you as a newly elected, appointed deputy head and says something like, you know what just happened? I have this case against that very respected judge. The case seems very legitimate and the facts are like solid and supported by evidence, and yet I was visited by another judge from the same court, and it was a very strange conversation because it was something between providing me advice and sharing very honest opinion, but it could also be read like an attempt to influence me, to drop the case because the other judge thinks that the prosecuted judge is a very good guy and it shouldn't be taken so seriously because it's just something very small. How would you evaluate this behavior the inspector will describe to you as an issue of professionality or independence or impartiality, and how would you handle such situation?
Frankly speaking, this situation looks like an attempt to transfer a responsibility from him or her to their manager, to their head, who doesn't have this function. Because he comes to me and says that it was such a communication, such a talk that looks like, or maybe doesn't look like, maybe I heard, or I misheard, or didn't hear. As I mentioned earlier, disciplinary inspectors and the Service of Disciplinary Inspectors shall be arranged as knights of a round table. They are all equal between each other. They all should think by themselves. They shall all bear their responsibility for their own decisions. And they should not try in any way to avoid a task assigned to him or her. One thing is conflict of interest. If, for example, this disciplinary inspector was an assistant to this judge and he prepared a decision based on which we have now disciplinary complaint. Here we have clear conflict of interest, but you know a story that I have seen something, I have heard something, maybe I was told, maybe not. And we will just enter into the vicious circle of repeated auto-distribution of cases, and we will end with a station when no one will be able to consider any cases. So that's why I see no grounds for repeated auto-distribution of cases. If a person thinks that he or she is not capable to handle this specific case, if this person thinks that because of different reasons they are biased, or they think that it's better for them not to be here, not to be specifically involved in that case, they should report using, reporting statements, saying that they can't do it. Okay, upon such statement, we will do repeated auto-distribution of cases. But because of the fact that there were some hints, some facts, some other things, it's not a reason, not a ground for doing auto-distribution. And I'm not a priest.
Said that you read it maybe as an attempt to transfer the responsibility from him to you, from the inspector to you. So what should he do in such situation? I'm not talking about recusal. I'm not talking about him sharing this information just to get rid of the task. I'm saying about the situation where this inspector was taken by surprise that this conversation even happened, because he wouldn't expect this high position judge approaching him and sending some mixed signals. So he was more in a shock than trying, oh, I don't want to deal with this case, I'm afraid, or no. What he or she should do in such situation, in your view? If you say, don't transfer this responsibility to me, what he or she should do?
Ця робота
This work will be uninterruptedly related and connected with some kind of pressure or attempts to pressure some things which could seem like something. There will be information delivered from different sources in different forms, and the fact that this information is delivered to us doesn't mean that this disciplinary inspector is going to listen everything to, and then he's just shocked and he doesn't, and he will go in some different direction. In such situation, when this disciplinary inspector hears something or thinks that it's something, and if this disciplinary inspector thinks that right now, specifically, he or she under an attempt to influence on their decision, then no problem at all. A reporting statement should be submitted to the head of the service or to his manager, and we will consider this case according to the procedure. But we should differentiate real pressure and, it looked like a hurt or sin, because this service is established in order to solve the problems rather than to create new problems. Because if each disciplinary inspector, thinks that he or she saw something, heard something, and we will go, all our service will be discredited. All disciplinary inspectors will not do anything at all, because there will be either a conflict of interest or some such things that they saw or heard something. So we should differentiate real grounds for such procedure, and when you are ready to put it on paper that yes, indeed, this person told you this thing according to such circumstances, and also to explain how actually you happen to be in this specific circumstances, in this specific situation, where you come across that specific person, that such situation actually happened. If you're ready to put it on paper and you see it, how it looks like, yeah, please, reporting statement to your manager, to your head, and we will consider it. All other things, it's an information flow which is not important for consideration.
I would like to ask one more question regarding your answers and responses. You mentioned that you wanted at some point to write a complaint against judge about judge's actions or behavior, I don't know. So, and you would do this if the law would allow. So what was the situation or situations when you considered this?
це було
It was, frankly and obviously, a legitimate decision, which actually we challenged in the appeal institution and then challenged also in the Supreme Court, and we won that case. But there are some decisions where you could be doubt about it, but the others could be very obvious, ungrounded positions which are actually non-acceptable for law specialists. And here, I don't mention a judge, I mention just a person with diploma. Yes, this situation took place, but why do we need to apply any other measures if you have appellate institutions, appellate courts? We challenged that decision in the appellate instance. Then that party tried to go to the Court of Cassation, but the Supreme Court was completely on our side. Yes, that was such case, but we won our case using legal measures.
shows in this kind of action, but anyway, you consider that it could be a ground for disciplinary liability of a judge and disciplinary complaint against judge, this not reasoned judgment.
Однозначно.
Yeah, definitely yes. If such case, specifically now, we have an appellate decision of the Court of Cassation. If this decision is subject for disciplinary proceedings, that yes, definitely, I think that it will be considered as unacceptable behavior of a judge. But in my actions, I always, compare efficiency and the process. For legal services, you need to pay. And the person who trusts a lawyer, this person needs some results. And in this case, the result was to stand for the property interests which were not defended or protected in the court of first instance, not to pay for the lawyer's fees or not to have a trial, but to protect, to stand for property interests of a person. So that's how it works. And the complaint, it's more for abstract nature of matters which can't help this person in any other matters in any other manner. That's first thing. And second thing, I think that karma is even more reliable method to renew justice rather than a disciplinary complaint. That's why, frankly speaking, I would like to confess that I will not be among the first persons to submit a disciplinary complaint. For me, it's non-efficient usage of resources. First of all, my resources regarding some possible future results.
I wanted to follow up on that. So you had a case, and it sounds as though you lost at the court of first instance, and then you appealed, it went to the Supreme Court, and you won on appeal.
Так, ми
Yes, we lost in the first instance. So in the first instance, we lost as a plaintiff, but in the Court of Appeal, we submitted, we filed actually the appellate complaint, and we won. And then in the Court of Cassation, they tried to challenge the decision of the appellate court, but we won. Actually, I was so surprised that it was May 2022, because at that time, at that period of time, it looked like that everyone was frozen and no one is interested in in court proceedings. But then they challenged it, and I was shocked how you are actually not afraid of going to the Supreme Court and challenging it. But they started it, but we won.
Described, and I believe you were describing the judge in the court of first instance, and you said this was unacceptable action of the judge, and you felt it was subject to discipline. Can you tell me what conduct you thought the judge engaged in that was unethical or that was subject to discipline?
A judge was absolutely incorrect in application of material and procedural legislation. Even a first-year student would not do it, because actually lawyers are taught about it, are told how to do it on the first year of their studies. Actually, judge refused to take into consideration the decisions and practice of the Supreme Court. He was just blind, and he refused to take into consideration any arguments and any evidences, and it was so obviously incorrect. And I rarely faced such non-professional actions, even if I actually didn't see the signature of the judge under this decision, I would not believe that it's the judge who could do it. Only, only second-year student could do it.
Do you think then that anytime a judge makes an incorrect decision, that is unprofessional conduct and should be subject to discipline?
Ні, звичайно.
Not of course. Mistake could be done by anyone, but you should differentiate a mistake and intention to have a legitimate decision. That's absolutely different things. Each judge has their own beliefs and understandings. So a fact of not satisfying the motion, it's not a problem. Party could be wrong, or party could not collect necessary evidences. That's what I explain to my clients every day. You could be 100% right in your own heart inside you, but if you have no evidences, you will not achieve the necessary results in court. That's how the system works. You should be compliant with general rules, which are the same for everyone, but you should be you should differentiate intention, ill intention for illegitimate decision. With common sense and being fair and fulfilling their duties, a judge could not have done it. It was just so screaming case for my 15 years of work. I have never seen any other cases before, and I hope I will never see them again. That's why. That's my answer. This is, it could happen like this. Very rarely, but could happen like this. Any person could have a mistake. Even your decision is, cancelled, and the new court of new instance, new challenge, and so on. There are so many nuances, so many different interpretations everywhere, but not in the case when a person is focused on making illegitimate decisions. At that time, there was very interesting episode of considering a case in the Court of Appellate, when actually the lawyer of another party was told that, we would like to look at your guarantor who actually dared to come to court with such standing, with building such arguments. For me also, it was one more element that actually strengthened and fostered my belief into justice.
Дякую.
Thank you. Thank you, dear Anastasia, for your frank replies. Let's move to the next part. That's property integrity. Here, I would like to say thank you to you for providing quite comprehensive replies to our questions, but I have a few small questions. That's why I expect the same frank replies from your side as it was before. The first question related to failure to declare income of your husband. Please explain why it happened like this. So those documents were filled in by January 2021 all at once, and at that time there was coincidence of several events. My husband was a private entrepreneur, and he needed to submit some documents, some reports. Without those reports, he didn't have specific figures. And before he submitted those reports, he didn't have those figures. I could have submitted some rough figures, some rounded figures, and then explain why there were some discrepancies in my data and his data and dates and so on, or just to put a mark that I don't know this figure, because there still was time for him to submit those declarations and those reports. Secondly, at that time, there were some health problems in my family, and my family was focused on those health problems rather than on declarations. That's why declaration was submitted how it was. Okay, thank you. And one more small question. In your documents, you mentioned that you have or you had a lecture on public procurement. Tell me, please, so your income for the previous year, what was your income for the previous year for these activities, and to whom you provided those services? I provide such services to the same organization which has the journal where I publish my articles, my materials. For the previous year, it was around 10,000. So actually, I indicated it in my declaration. It's according to the agreement, official agreement. I receive it officially, maybe 10 or 15,000 of hryvnia, not that much, but I declared it. So I'm a speaker for different teams, for different audiences, which are actually arranged by this organizing company which organizes those events. Thank you so much. And the last question on this topic. So if you have any of those three positions in the Service of Disciplinary Inspectors, will you continue providing such services, specifically as a lecturer? From the perspective of the law, there are no obstacles because that's a teaching activity, and I could combine it with any civil service if I have some time and opportunity for it, and that, causes some doubts. And, we will see it, how it goes. If there is no time, no opportunity, then there will be no such lectures told. But at the same time, I value this part of my work because it's also about educational activities. It helps people to understand law in a more correct manner, not to repeat mistakes. Because I always try, to be as much direct and frank as possible in provision of information. And public procurement field is so dynamic, is so evolving. Almost each 2 years we have a new law, and for example now there is a new draft law under consideration of the Verkhovna Rada. That's why, to be involved into this topic. I have been with this topic for many years. I anyway will monitor what is going on there in that field. I will anyway continue reflecting my knowledge in different articles because, in order to be qualified to explain this information to others, you should know this topic very well by yourself. I have heard once the following wording: if you can't explain a topic to 5-year-old child, you know nothing about it. That's why I always try to put it in such a format. If I manage to explain it in so simple words for a child to understand, then it's okay. I know it. I know the topic. It's just a good skill to process information. Thank you so much. That's all from my side on this specific section of questions. Dear colleagues, over to you.
So I will start with what you just said. How would you explain to 5-year-old child for example, the functioning of the Service of Disciplinary Inspectors?
I would say that it's such a house where people come if they something, didn't like something so much in a court. There, in that house, they could tell what actually they didn't like, what insulted them in a court. They could also share their memories, their situations, maybe even to correct the situation. And if indeed this person was insulted, they will help them there. But if this person is incorrect, they also will tell this person that this person is incorrect and they should do it in another way.
And I would like to understand better one part of your earlier responses, and it was connected to the earlier remark about the service, or no, I will formulate it more in a simpler way. If I understood correctly, you said that the disciplinary action itself is not always the most effective way of fixing the problem. Did I understand correctly? Can you elaborate more? What do you mean by this in the framework of the Service of Disciplinary Inspectors?
Once I had a very interesting case in my practice, maybe the most unbelievable. I have never had such emotional and painful case. So for for claimant. So actual claimant, that was a woman, she wanted to take out a tomb from the cemetery of a neighbor. So she thought that this specific part of cemetery was dedicated only for her family and only her relatives could be buried there. And she was so in pain of all that situation. And she said that, oh, that's, stranger. That's another person who is buried here. This person buried there actually makes troubles for everyone, and that tomb, and that everything, and that path, and this bench, and so. But I try to appreciate her that even there is no law in Ukraine to allow a judge actually to force other people to take out this person, this deceased person, from cemetery and bury them in another place. But imagine, even if you are going to win the case, where you find a person who will take and do this thing, who will take a shovel and will bury out this person. If I win, I will go and say, I believe in God, I go to church, and I'm not going to implement this decision and to fulfill this decision. Why I told that story, actually? Thanks God, we managed to achieve reconciliation. And why actually I am telling this story? Because for many persons, a disciplinary complaint is about this, that I'm going to stand up and say that's about sharing their emotions, some kind of anger, some kind of, of those displeasures, of grievances, and so on, whatever they have. Not for everyone, this disciplinary complaint is about achieving some kind of punishment for a judge. No, for many people it's just about this process of sharing their sufferings, what they suffered, how they were just angry, how they were shocked, just to share this with someone. And that's why at work a disciplinary inspector will have such complaints, will have such situations. That's why indeed such a disciplinary complaint, despite of all its importance and specific value for specific persons, certain persons, is not a thing which could decide on fate of this or that person. So, going into the light of disciplinary complaints, I would like to hear your opinion regarding complaints. Did you have such experience that complaints are submitted against a judge who is, punished? What do I mean here? There are such cases when a lawyer understands that nothing can be done in the legal field in terms of the legitimate position. Decision was made by a judge in a legitimate manner, it's lawful, but someone doesn't like it. And then one of the mechanisms, is also to submit a disciplinary complaint. We can't always say that actually complaints are submitted only by those who are indeed faced huge injustice in courts, but we have also a category of such professional complainants who know and who do millions of complaints, who file millions of complaints, and the fate, the destiny of such millions of complaints is just not to be considered at all. So 80%, according to the statistics, 80% of the complaints which are not considered at all, it's not because there are some drawbacks of those complaints, but because they just do not have any essence, any elements of disciplinary offenses. So if you have this opportunity, please tell me, do you see any solutions for this, maybe on a legislative level, for the Service of Disciplinary Inspectors not to be overwhelmed with these non-grounded, nonsenseless complaints, which would take so much time for you, but at the same time, those complaints, nonsense complaints, could take your time and resource and efforts from those complaints which indeed require your time and effort. From my personal experience, I could, on the civil service, I could say that, so, maybe not disciplinary complaints and not complaints, but some motions we received. And consideration of motions was also under my duties when I worked in the in one of the previous places of work. And so consideration cases were divided into several categories. So motion on the merits, that when indeed motions were grounded, they required significant attention, and in future those motions were never lost and became a part of future inspection. Second category, people who are just bored with their lives. It's not only about, for example, some budget issues, but for example prices for shampoo or prices for ham or eggs and so on, and there were so many different letters and motions, and usually we just replied that sorry, it's not under responsibilities of our court, but we will refer your motion to the anti-monopoly committee or any other instance. For example, what you mentioned, professional complaints which no, those complaints could have been submitted by deputies of village councils or other councils, would also deputies' requests covering so many different issues, and we also we were obliged to consider all those requests, all those cases. That's why I understand specifically that there could be such a huge flow of nonsenseless issues, and we could be drawn under it. But anyway, one physical person can't make so many complaints, so many things. Each could do one. Okay, if each person files one motion or complaint, it's not a problem. But if this is a systematic approach, the same lawyers file systematically non-grounded complaints, then at the same time taking into account and respecting right to practice law and the forms how the law could be practiced, I think at the same time that it would be quite reasonable to generalize the situation, and upon analysis, if we see that there is some kind of systematic approach, for example to compare with some hacking attacks, it's IT systems, and if we see that there is similar attack at High Council of Justice, at our service, then it would be reasonable to reach out to lawyers and bar unions, self-government unions, to deal with this situation, for them to ensure compliance with professional ethics and disciplinary work of their members, of their advocates. What do you think about an idea to pay a court fee when the person files a complaint? Because also there are some discussions taking place. It's not that it should be thousands of hryvnias, but maybe even 100 hryvnia would stop a person to file a complaint. If to stop them from filing non-grounded and nonsenseless complaints. I think that those who are professional in doing it and doing it in a systematic manner, it will not stop them. They will just send that complaint and file it to the HTJ without receipt and confirmation of paying this court fee, and we will be forced to consider it. So it will not work for them. And for those professional advocates, professional lawyers who will do it in the systematic manner, this 1,000 hryvnia will just become a part of their honorarium, of their lawyer's fee. As often as I can see right now, there are some cases which should not be considered at all, even if a court fee is paid. These are not those cases to go to the court, to file a complaint, to spend your time, emotions, efforts, and even documents and paper in the court secretary to do it.
Yeah, I think we had a lot of questions and very intensive interview. So thank you very much for your open responses and answers. Maybe you have some final comments or remarks you would like to say them. So the floor is yours for final comment.
Я думаю, я просто
I just want to say thank you to you for your time, for your interesting questions. Yeah, actually, for me also, it was interesting to have some thoughts about it in my spare time. Thank you. Goodbye.
Inform you that the decision on the results and on the winners of the competition will be made after 2 weeks of interviews, after the final interview will be conducted. So thank you very much.
Да, я так і
Good luck.
подумала.
Yes, that's what I thought. Thank you so much. Goodbye.